Today we will discuss this case Sanjay Kumar versus State of Haryana. Punjab and Haryana High Court decided on the uh, 1st of 10th of January 2013. See the facts of this case. Facts of this case are very simple. That every bank now uses online transaction, and for that they require a software. So bank official does not know much about the software. They always have the contract with a company that provide the software, and also have provide one person who will look after if there is any problem in the working of the software. So in this case also it happened that this bank, Vijaya Bank, this Vijaya Bank uh, has the uh, contract with Veermati Software and Telecommunication Limited, and to this particular software company they have contract to maintain the software supplied by them to the bank, and also looking after the any difficulties that bank official if come through with in the functioning of this software. So the Veermati Software and Telecommunication Limited has deputed one person, Mr. Sanjay Kumar, and Mr. Sanjay Kumar duty is to look after that the software provided by this company will properly function for the bank transaction. Now this person has opened a saving account in this particular branch from where the case arises. This case is basically from Vijaya Bank NIT Faridabad. So in this particular branch, the person that was deputed by the software company to look after the functioning of the software has opened a particular saving account, and then he, because he has the access of the this software, also having the access into the accounting system which was computerized, and also in position to enter in ledger and various other account. And so having this accessibility, he made some changes in the software, some changes in the entries, and then the money from the some other account holder were get transferred to his own account, and then he withdraw that money through the bank or through the the transaction clearance line. So through this means he has drawn nearly 17 lakh rupees of the money. When this discrepancy was before the bank officer, they found out some miss you can say the transaction, and then they the branch manager has called this person, and he inquired that this amount is credited to your account, but you have not submitted, or there is no corresponding the document with respect to you. Then this person has admitted that yes, he has embezzled 17 lakh rupees, but he has not disclosed the modus operandi, that how he actually committed. Okay, and he also assured that he will return the money. Then the senior the branch manager, because he was aware that this is not the normal matter, this is the money matter, maybe it would create the problem, so he lodged the FIR into the nearest police station, and then the FIR was lodged against this person against the various sections of the Indian Penal Code, along with the section 65, section 66, and section 67 of the IT Act. Section 65 tampering of the source code, section 66 that he did unauthorized access and altered the information, etc. And section 72, that is the breach of the confidentiality. Then along with IPC section 420, 467 and 468 and 471, forgery, etc. So these sections were imposed. He was tried duly by the magistrate, first class Faridabad, and he was sentenced on the in 2011. Then he made the appeal to the session judge, and then his appeal in the session judge was dismissed, and then he moved a revision petition. See, there are review and revision. So review is done by the same court and revision by the high court. So this is the criminal revision petition filed before the Punjab and Haryana High Court, because Faridabad come under the jurisdiction of Punjab and Haryana High Court, and the issue is before the Punjab and Haryana High Court. Now, when the charge sheet was filed and trial was started, he pleaded non guilty. I think all these terminology we, as a student of criminal law, we all aware. Now here the question is that whether the section 65, section 66 and section 72 has been made out or not made out. The person, Mr. Sanjay Kumar, has argued. He argued through his counsel that there is no direct evidence that he got access and he transferred or he made any change in the entry or in the software. And so in light of that, it cannot be said that he committed the offense. The second thing is that section 72 and section 72 of the IT Act is talk about the confidentiality. Without prejudice to the first argument, even if Sanjay Kumar have the knowledge, he has not shared that confidential information to any other person, because there was no allegation that some other person has used that password, etc., the access he had. And so section 72 that talk about confidentiality and privacy, and it says, save as otherwise provided in this act or any other law for time being in force, if any person in pursuance of any of the power conferred under this act, rules or regulation made thereunder, has secured access to the electronic record, book, register, correspondence, information, document or other material without the consent of the person concerned, disclose such electronic record, book, register, correspondence, information, document or other material to any other person, shall be punished with imprisonment of term which may extend to 2 years or fine which may extend to 1 lakh rupees or both. So here the main gist is that the person who secured the access must has to inform to any other person. And the facts of this case are not saying that there is another person that is involved and to whom Mr. Sanjay Kumar has disclosed the information. Now, when you see this case, the first para of this case is talking about this first para, that how from the case history, that how case reached to the High Court, that it was criminal revision petition, and then there was the delay also, that was condoned. Then in the second para you will find the case history, the when FIR lodge or the judgment pass, etc. And then in this last para, the brief facts of this prosecution is the main facts on which the FIR got registered, etc. Then you have to read this para. After that you come to the last of this case, because you will find exhibition, different evidences that has been examined, and finally we have to read the arguments from here. The argument I have told you. from the para number 16, because para number 14 is talking about about 420 etc. So we are not concerned here about that. Even if you want to read, you can read it. We are concerned about that the three sections that have been imposed on Mr. Sanjay Kumar, section 65, section 66 and section 72, whether these section has been duly proved or not. As far as the section 72, you can read from here. Even I have read this the statute, that although on the page number 35, I am just bluing it. Although accused was having secured access to the electronic record of the bank, he forced the entry and cheated to the codes gained to himself, but there is no such breach of confidentiality by disclosing the information to any other person. As such he is acquitted of the offense of 72. Acquitted does not here means acquitted for all the charges. He is acquitted only for the charges of section 72 of the IT Act. Now with respect to the the other offenses, section 65 and section section 66, we have to read the para number 14. In the para number 14, because there is no direct evidence and how the High Court has decided this case. Para number 14 I am reading, you can also read with me. On the other hand, the learned counsel for the accused during the course of argument has argued that no specific password was allotted to Sanjay. However, no doubt password is given to an employee, but it has surfaced in the testimonies of the prosecution witness that for the purpose of maintaining the software, and in this manner had access to all those files to which only the employee of the bank could have. Moreover, as amount was deposited in account of the accused, he has withdrawn it and there is no force in the said argument. So this thing, that maybe it has to be committed by wrongfully by some other person. When the you have the access, then maybe specific password was not allotted, that is true. Then you have the knowledge, you have withdrawn the money, you have not objected that in my account this money has come, from where this money has come, etc. So all these facts, circumstantial evidences shows and confirm that he committed the these activity. Now whether section 65 and 66, for that we have to read para number 16. Furthermore, clearly the accused has tampered with the computer source document, and he has also altered in the information which is resided in computer resource. By doing so, he committed. So two activity he did. One is he tampered with the computer source code, and when a person tampered with the computer source code, then section 65 is attracted. And the second one is when he changed the entry, that means the data that is present there, he made the change in data. When you see section 43 and section 43 read with section 66, that means any activity committed under section 43 with dishonestly or fraudulently make it a punishable offense under section 66. So these activity from the para number 14, when the counsel of the Sanjay Kumar has argued that there is no direct evidence, and in the criminal law it is always that the burden is strict, it has to be proved beyond reasonable doubt. But it's not necessary that always the facts has to be proved by the direct evidence. Sometimes the circumstantial evidences also has to show. The first circumstantial evidence is that he has the access, not the the specific access, but still have the access. The second, that money that is any entry that is changed, why all those entries have changed the money in his account, and that is credited, not the debited. The third one, he has not complained कि उसके account में पैसा जो है credit हुआ. He clearly have withdrawn, and that is for many times. So all these circumstances shows, all these facts shows, and when you read judgment, you will find many exhibits that he withdrawn the money. That means he had the knowledge. And so all these things are duly proved, but it is not directly proved that he committed that part. And so through the circumstantial evidences, high court satisfied, and said that yes, as per section 16, section 65 and 66 is committed, but at the same time section 72 has not been committed, and accordingly it was dismissed. So to this effect, it was decided. So we have to discuss whenever there is allegation about the section 65 and section 66, to see with this aspect. So this is the end of this case.